Chevron involved a two-step test requiring courts to ask first if a statute was ambiguous, and second, if the agency's rule interpreting that statute was reasonable. If the answer to both questions was yes, the court was to defer to the regulatory interpretation of the statute. In the 40 years since Chevron was decided, it became the most cited Supreme Court administrative law decision, and the CAVC alone has cited Chevron in 170 of its precedential decisions. Earlier this year, on June 28th, the Supreme Court issued its decision in Loper, reversing Chevron as inconsistent with the Administrative Procedure Act, or APA. In particular, the court held that the APA's charge that courts decide all relevant questions of law when reviewing an agency action conflicts with Chevron deference to agency interpretations. As a result, courts will no longer defer to an agency's interpretation of an ambiguous statute, and instead must decide the single best meaning of that statute. The Supreme Court did not, however, overrule individual cases applying Chevron, and those cases continue to be binding law. Although courts will no longer defer to agencies' regulatory interpretations of ambiguous statutes, courts may, under a separate doctrine called Skidmore, consider the agency's expertise as one of several factors when trying to decide what the best meaning of a statute is. The Supreme Court also emphasized that sometimes the best meaning of a statute may be that Congress intended to give an agency discretion in how to carry out the statute, such as explicit authority to define terms or to fill up the details of a statutory scheme. Loper does not direct Congress or agencies to change how they legislate or regulate. It only speaks to how courts should review statutes and the regulations interpreting those laws.